Welcome to the Carpenter Law Firm seminar on the latest LGBTQ issues in churches. We start at noon. This is a bring your own lunch 59-minute seminar. So thank you for joining us. Today, this seminar is accurate as of information April 18th, 2024. This presentation is made in Arizona. It is intended to be an overview of Arizona law. If you're watching this seminar from another state, it may be applicable. It may be inapplicable, but it is presented from an Arizona-based law firm. It is intended to be accurate legal information for an Arizona-based church, but no legal advice is provided. If you need specific legal advice, you should consult with an attorney to obtain specific legal advice. So when we talk about LGBTQ issues in churches in 2024, we mean to speak to the issues that come up routinely or that are happening in churches that confront LGBTQ issues. From an overview perspective, one of the things that we are concerned about is some of the schisms that have come up in certain of the denominations in America. And I want to point out a few of these for you by way of overview. The Global Methodist Church is a new denomination that has been receiving United Methodist Church congregations across America. Give you a quick overview of how these new denominations have given their viewpoint, a doctrinal viewpoint on LGBTQ issues. The Global Methodist Church has a statement on LGBTQ issues. It's quite simple. Their doctrinal statement is, we believe that human sexuality is a gift of God that is to be affirmed as it is exercised within the legal and spiritual covenant of a loving and monogamous marriage between one man and one woman. And the Global Methodist Church cites scripture to back up their doctrinal position. The United Methodist Church, one of the oldest and largest denominations in America, has a statement on equal rights regardless of sexual orientation. Their statement says, certain basic human rights and civil liberties are due all persons. We, the United Methodist Church, are committed to supporting those rights and liberties for all persons, regardless of sexual orientation. United Methodist Church has behaved consistent with this doctrinal position. They have ordained pastors and have acted consistent with this doctrinal position in ways that have bothered or created friction with certain congregations and certain people within the United Methodist Church that have caused an exodus of certain congregations to the Global Methodist Church. And some of you know that the United Methodist Church has congregations across the world, and many congregations have moved to the Global Methodist Church because of friction over these two doctrinal statements. As you can tell by looking at this screen in this Zoom webinar, that these two statements are fundamentally different. They say different things on the same topic. Schism within the Methodist Church. There's also schism in the Presbyterian Church. ECO, a covenant order of evangelical Presbyterians, is a new denomination that has been receiving Presbyterian USA congregation churches. If you know much about the Presbyterian Church, ECO is not an acronym for any particular phrase or group of words. Essentially, if you do a bit of digging, if you're not from the Presbyterian tradition, ECO essentially means ecosystem. The ECO Presbyterians have a statement that marriage is between one man and one woman, similar to the Global Methodist position. The Presbyterian USA Book of Order has this statement, several statements taken together. Marriage is a gift God has given to all humankind for the well-being of the entire human family. Marriage involves a unique commitment between two people, traditionally a man and a woman, to love and support each other for the rest of their lives. The sacrificial love that unites the couple sustains them as faithful and responsible members of the church and the wider community. In civil law, marriage is a contract that recognizes the rights and obligations of the married couple in society. And finally, the Presbyterian USA Book of Order states that in the Reformed tradition, marriage is also a covenant in which God has an active part and which the community of faith publicly witnesses and acknowledges. So, like the Methodist schism, the Presbyterians are struggling between the second bullet point here, that marriage is between one man and one woman, and the Presbyterian USA Book of Order, that these 4 bullet points taken together say something completely different. And one doesn't have to have their own view of LGBTQ issues to see that these statements are different. And one doesn't have to agree with one or the other to make the observation that these statements are different. You don't have to have a law degree or a PhD in logic to see that these are different statements. That's a schism in the Presbyterian Church. The Episcopalians have also struggled with the topic of LGBTQ issues, mostly with respect to gay marriage, as we've called it. The Anglican Church in North America is the name of the new denomination receiving Episcopal Church congregations. The North American Lutheran Church, and I'm not going to go into detail with their competing statements of doctrine on these issues. There is also a new denomination in the Lutheran tradition called the North American Lutheran Church. They have been receiving Evangelical Lutheran Church in America congregations, similarly around different views of gay marriage and whether marriage is reserved to one man and one woman. Interestingly, there doesn't seem to be any real debate over whether marriage can be between one man and multiple women. We're not arguing about plural marriage. That's mostly been left to fundamentalist Mormon issues. It's not about the one man and one woman issue. It's 2 women or 2 men. That seems to be the doctrinal argument. So that's the schism. And where the legal, I just want to point out that the Catholic Church appears on the cusp of change. The current Pope has been, according to observers, flirting with, maybe that's the wrong word, liberalizing the Catholic Church in some ways. Maybe this is more hope by some than reality. Some have hoped that the Catholic Church might become more liberal or progressive on these topics. But every time that it seems that, and this is from an outsider's perspective, I'm not Catholic, I've never been part of the Catholic Church, but every time it seems like the Pope might do something formal that's progressive on these topics, it doesn't seem to happen. But we'll see. It might take much longer if one is hopeful on that topic. And again, I've never been part of the Catholic Church. I'm not rooting for it one way or the other, but there appears to be some hope that the Catholic Church might change. And I'm simply pointing this out for the sake of trying to be complete. An underlying challenge for churches is that there is an incongruity between church doctrine and the manner in which American churchgoers answer poll questions about their personal views about LGBTQ issues. And we see this in the polling data done by national polling organizations that have been asking questions of the American electorate for decades. And what we see in the data is that Americans have become more tolerant of LGBTQ issues. And what has happened in many cases is that people who go to church may have an aunt or an uncle who's been living with or married to a partner for 20 years, and they see them at Thanksgiving, and they also go to church every week. And so that's an underlying challenge for churches, is this incongruity between church doctrine and the manner in which churchgoers answer polling questions about their personal views about LGBTQ issues. Now, many would say, and my father-in-law was a pastor for over 50 years, my father was in ministry for many, many decades, is that what ends up happening is church folks would say, that doesn't change the doctrine. Scripture doesn't change just because there's an incongruity between someone's personal views because their aunt or uncle has been married to a same-sex partner for 20 years, and someone is able to love that person in their family and share Thanksgiving with them every year. That doesn't change the doctrine. That doesn't change Scripture. That doesn't change anything about the doctrinal statement. And so the incongruity can exist. Nothing about the church's doctrine or the church's behavior has to change because of the incongruity. I understand that completely. As a lawyer, there's nothing about the doctrine that has to change. Legally, there's nothing about that matters. But it is the world in which the church has to operate. Its mission is this underlying challenge, the incongruity between the doctrine and the personal views of some of the congregants who attend the church. And as a lawyer, it's easy for me to say, well, it's not my problem. It's a challenge for the leadership of the church. It's a challenge for the lay leadership of the church to deal with what I'm now calling the incongruity, the polling data, the personal views of some of the people in the church. But the doctrine doesn't have to change. The scripture doesn't change because of the personal views of some of the people in the church. So when we talk about schism, let's talk about the legal issues. There are what I call reverse merger challenges. When a congregation decides that it can no longer abide or deal with the progressive or liberal views of the denomination, who ends up with the church property? Who's going to own the building and the real property? When lawyers talk about the land, we talk about the real property, the real estate, and we also talk about the personal property, the items in the church building, the money in the bank accounts. Who does that belong to? Does it belong to the denomination? Does it belong to the body of congregants who have been meeting there? These are sometimes complicated legal issues when there is a schism and the congregation decides we no longer want to be affiliated with the denomination that has deviated from a traditional biblical view as the schism sees it, as the congregation views scripture. Let's say their view is one man, marriage is between one man and one woman, and they view the denomination as deviating from that. And so the congregation decides we no longer want to be part of a denomination that has, and I'll use an example, become too progressive or too liberal on these topics. Who ends up with the the church building. Now I'll concede that the church is people. The church is not necessarily the building or the real property. It's the way I see it. And so we end up with an argument about the physical structure and the land, the real property. Legally, who does that belong to? Does it belong to the denomination? Sometimes the land is titled, deeded to the denomination. Sometimes it's deeded to or titled to the local congregation. And so schism can create some real tricky legal challenges for lawyers like me to work through when a congregation wants to depart the progressive, liberal leaning denomination. How are we going to work through that? And that's been some of the more challenging legal projects I've worked on in my 30-year legal career, working with churches and other religious institutions, is an amicable parting of a congregation that wants to leave a denomination, sometimes over this issue. And that's why I bring it up in this context or within this discussion, is that these schisms can create reverse merger challenges or church split challenges, sometimes in the real estate realm, who's entitled to the property. And sometimes these church properties are very valuable on the open market. If we had had a conversation before the pandemic, what would happen if there were a worldwide pandemic? Would real estate values go up or down? Would we have predicted that commercial property, churches tend to be considered commercial property? Would we have predicted that commercial property values would go up by 30 or 40% in some markets? Here in Arizona, again, back to this is an Arizona presentation, would we have predicted that commercial property values would go up by 25 to 40% in some cases, and that church property would be at an all-time high, at least within the last 30 to 40 years? The church property would be so valuable on the open market, not just for church use, but in some cases for redevelopment, for tear down the church and turn it into apartments, turn all that acreage into housing or condominiums or some kind of other adaptive reuse. No one would have predicted that in advance of the pandemic. If we'd sat in a conference room and had a whiteboard and said, after a worldwide pandemic, would the church property be more valuable or less valuable? I'm not sure I would have participated in the group of people who would raise their hand in a facilitated discussion. Will property be worth more or less? And if more, who would raise their hand to 25 to 40% more? Church properties are valuable on the open market. Who needs to pay for that? Is that value that has to be added into a schism-related departure of a congregation from a denomination? Complex issues. And we end up in these discussions of these congregation departures from denominations having to consider these issues. How much money should be paid by a departing congregation to a denomination to account for the value of the property, if any? And sometimes these issues, when half the congregation wants to stay and half wants to go, become very complicated, legally complicated, and also complicated from a church governance standpoint. And what we find is that the corporate governing documents of a church become extremely important in these scenarios. What happens is that the church governing documents, which are often not available on a church's website, intentionally or unintentionally, where are they? Are they in a steel filing cabinet in the corner of the church office? And when we go to find them, are we grabbing the documents and holding them up and blowing dust off of them? Have they been consulted in years? Are they up to date? And by up to date, what I mean is, do the documents reflect the governance condition on the ground? This is one of the most important questions I pose to my church clients routinely. And by the condition on the ground, I mean, do the bylaws and the other church governance documents reflect the way decisions and governance are actually done? Or do they reflect the way things were conceptualized in 1992? I'll give you an example. Do the bylaws say that the lay leadership team, let's call it your board of elders, your deacons, board of servant leaders, board of directors, give it whatever name you want to, board of trustees. The name of it is not critical. Let's call it your lay leadership team, your board of overseers. Do the bylaws say that the board will have 7 people? But nobody can remember a time when it ever had more than 3 people on it. That's a problem, because I'm using a term I've used before now, there's an incongruity between your documents and the condition on the ground, the way you actually operate. And that incongruity, that difference between the documents and the way you actually operate is it an actual problem? Well, it's different. The documents do not reflect the actual manner in which the church is governed. The documents say the board of overseers, the board of trustees, the deacons, the elders, whatever word you use for your lay leadership oversight group, not your paid pastoral staff, will have 7 people. But in fact, there's only 3. What it demonstrates from a legal standpoint is that the church does not spend energy or effort respecting the corporate governing documents, and that it's not important for the governing documents to be honored on a day-to-day, week-to-week, month-to-month, quarterly, or annual basis. And so what happens is that when it's time to pull out the corporate governing documents to deal with a schism and to consult them, we've demonstrated they don't really matter that much. We don't honor them in the little things. And now it's time for the congregation to respect the church governing documents in the big things. The big real estate related congregation is splitting governance issue, yet the church doesn't actually care about or honor the church governing documents in the straightforward things, like the board of overseers, deacons, elders will have 7 members, that nobody can remember a time when that board had more than 3 people. We need the documents to reflect the actual condition on the ground governance, the way things are actually done. Litigation, when it comes to schisms, I wonder if the plural of schism is schiza, but I've been told it's schisms. When it comes to schisms, litigation is unusual, but it does happen. Why is it unusual? Because in Arizona and across the country, there is a legal doctrine called the church autonomy doctrine. What the church autonomy doctrine says is that judges and courts are unavailable to resolve doctrinal issues in churches. This doctrine is also called the ecclesiastical abstention doctrine. The legal doctrine requires judges to abstain from resolving doctrinal questions. There may be a judge in federal court or in state court, and this is applicable really across the country, that believes that gay marriage is important and that it's fair and just, and that the church is wrong to be against it. That the doctrine that says marriage is between one man and one woman. The judge may believe in his or her heart and mind that that doctrine is wrong-headed and incorrect in his or her own belief system. But the judge would be required to abstain from ruling in a court case that that doctrine is wrong, because the church is entitled to have its own doctrine, and the judge is required by the ecclesiastical abstention doctrine to abstain from judging or making any ruling that that doctrine, back to the earlier slides about marriages between one man and one woman, the denominations that have taken that position, judges are required to abstain from deciding that that doctrine is wrong. The church autonomy doctrine also says churches are entitled to autonomy in their own church affairs. It's basically another way of saying the same thing. So although litigation is unusual, courts are available in some cases to decide whether or not a church has followed its own corporate governing documents or a denomination's own governing structures and a church's own governance when it comes to resolving real property disputes. So we do have to be concerned a bit about that. But the courts will not resolve doctrinal questions. If someone goes to court and says, my church is wrong for its position on gay marriage, the court should throw it out almost immediately on the basis of the ecclesiastical abstention doctrine. Courts are not available to resolve a doctrinal question. If someone goes to court and says, Judge, I want you to resolve infant baptism, a judge should throw it out immediately. That's a doctrinal question. And the judge should say, nope, I'm not here to resolve the doctrinal question of the value or the importance of infant baptism. Not available for that. That's another example. All right, let's talk for a minute about the Supreme Court decision that legalized gay marriage across the country in 2015. It's been 9 years. Obergefell v. Hodges. The initial concern back in 2015, and we talked about this in some seminars that I did for church clients and friends back at the time, the initial concern was that the LGBT community would demand weddings in church venues. What's happened in 9 years? Well, that has not happened in statistically significant numbers. But there have been some secondary concerns, and I'll tell you what we have encountered. The secondary concern is that a church staff member would perform a wedding off-site on personal time. Here's the scenario. The scenario is that the youth pastor has worked with a person in the youth group for 4 years. They become close. The youth pastor has counseled this young person through this young person's personal challenges and struggles, as the church would expect and require. It's the job description. A couple of years after the person graduates, if you will, from the youth group, the young person asks the youth pastor to conduct their same-sex wedding in the park on a Saturday afternoon. And the youth pastor performs the ceremony and pronounces the youth group graduate married to the same-sex spouse. Does the church care? And this is the question for really any church in this scenario. Does this violate an employment policy of the church? And if a church senior pastor or lay leadership team would be bothered to see a social media post of its youth pastor, and I'm picking youth pastor just for ease of the hypothetical, performing a same-sex wedding in the park on a Saturday night. We need to tighten up the policies now. And what we find when this happens is that the social media post tags the youth pastor. Everyone connected to the youth pastor is going to see that it happened, and it's going to move through the church Saturday evening, Sunday morning, all day Sunday. It's wildfire. And all of a sudden, it's going to erupt, if you will, in the church. Now, anybody who's been in church work for very long knows that these things happen. By these things, I mean things travel through churches quite quickly. Is it going to die down? Of course. And back to my point earlier that some people in the church will not be bothered by it. Some people in the church might be bothered by it. And so the senior pastor and the lay leadership team have to figure out how to deal with it. But my point as a lawyer is, does this violate the employment policy? If the church cares, are we okay with this happening? Because it could happen quite easily, especially if the youth pastor and the now married couple were close through the youth pastor years. So the question becomes, it's really an employment law question. Can a church prohibit its staff from performing same-sex weddings? Yes, on personal time. It is legal for someone to engage in a same-sex wedding. It is a permissible condition of employment to require a staff person to decline to perform legal unions in off hours. That is an acceptable condition of employment. You could say to your ordained staff people, you are prohibited from performing same-sex weddings in your off hours. That is a permissible condition of employment, and it could be subject to discipline or termination if a church were to decide to do that as a condition of employment. That's absolutely an acceptable position for a church to take. What's curious, does your employee manual address this with your staff members now as to what they can do on their personal time? Many churches would say, hey, do as many weddings as you want to and accept a gratuity for it in your off hours. But the assumption would be that these would be one man and one woman weddings, and many pastors supplement their income with weddings in their personal time and their off hours. And there's nothing wrong with that. Most churches would have no problem with it. Do as many weddings as you want to, and nobody would have an issue with it. But if a church believes that its safeguard against pastoral staff doing same-sex weddings is a doctrinal statement on the website, then my encouragement to my church clients and friends would be, you might want to ask your staff, hey, if the opportunity came up and somebody asked you to perform a same-sex wedding, would you do it? And I think a lot of people would be surprised at the answer. A lot of, especially younger church staff members, would probably say, yes, I would. Maybe depending on who it is, if it's somebody that I've worked with in the youth group, precisely the scenario that I've outlined, a good number of young pastoral staff members would probably admit, I would do it. If the hypothetical were, as I've outlined it, someone that a youth pastor has worked closely with turns up and says, I need to marry the love of my life, my best friend, and will you do the ceremony in the park? A lot of young youth pastors would say, of course I'll do it. And the youth pastor might not have the foresight to say, please don't tag me in your social media posts, because that's what's going to erupt within the church. And that may not even be the real problem. The church might have a problem with the fact that it was done in the first place. So we have this challenge, both as to whether it's done in the first place, and then the promotion of the fact that the youth pastor did it as a secondary matter. What the social media feed is the issue. So if you do care as a senior pastor or a lay leadership team, we may need to get work on the employment contract of the pastoral staff member or members, and an employee policy with a disciplinary process for violations. And I'm not looking for problems here. I'm simply pointing out that left unattended, this topic could come up quite easily. And our initial thought in 2015 was that people were going to want to get married in the facility. That hasn't happened. And in fact, what has happened is even people who've grown up in the church want to get married in offsite venues. Even my own adult children got married in offsite venues growing up in the church. And so even people don't want to get married coming down the center aisle to organ music the way it might have happened in the past. And so when we thought that after Obergefell, people would want to get married in the church, and that was what was going to happen, that's not what actually occurred. This is what is more likely to be a challenge for churches moving forward. So a final thought here on the topic of the LGBTQ issues in churches legally. In 2020, the US Supreme Court handed down a decision in a court case called Our Lady of Guadalupe School v. Morrissey Beru. Court cases are tough because they're named after the litigants. Our Lady of Guadalupe is now the case for the topic of the ministerial exception. The ministerial exception allows religious organizations, churches will use that in this context, to avoid federal anti-discrimination requirements in employment laws. And when this came out, we did a seminar on it. It's been kind of lost in the system. I want to cover it here so that it'll be on my website once we post this seminar. And what it says is, when you're using the ministerial exception to avoid federal anti-discrimination in employment laws, in other words, allowing churches to discriminate in employment, the focus must be on the employee's function and the religious organization's definition and explanation of a job's importance. So if we're going to be discriminating in employment based on LGBTQ status, a potential employee, based on a potential employee, it's not risk-free based on Our Lady of Guadalupe. We've got to be careful. And one of the things that's tricky about LGBTQ issues is that, unlike discrimination based on race, if somebody comes into your office and is applying for a job and they're African American, we generally know that because they're Black. You could tell by looking at them. LGBTQ is tough because unless someone tells you, hey, I'm gay, don't discriminate against me because of that, you wouldn't know. You can't tell by looking at someone, or unless they tell you, you wouldn't know that someone is gay or bisexual. That's the B in LGBTQ. Q is tough. Q stands for queer. There's no way to tell. T is challenging, transgender. Again, hard to tell. I think the transgender community would say that you're not supposed to notice whether someone is transgender. They would say, don't discriminate on the basis of someone being transgender, and it's inappropriate to notice, which makes it all the more difficult. Frankly, I find it to be quite challenging. You're not supposed to notice whether someone is lesbian, gay, bisexual, transgender, or queer, but you can't discriminate against them on the basis of any of these categories in the LGBT or Q in the LGBTQ. So we cannot discriminate. But the ministerial exception says someone cannot maintain a legal claim against a church if they're using the ministerial exception. So when this came out, we knew at the time when it came out, and we know now that a church can use a ministerial exception to avoid a claim of discrimination. So one of the things that people started thinking about or toying with, but I'll show you in a minute why it won't work. I'll give you some examples. Perhaps we can have a minister of landscaping. I'm joking, by the way, let's be really clear. A minister of sweeping floors, a minister of answering the phones, a minister of changing light bulbs. But these are jokes. Let's be really clear that this would not work if someone applies for a job and they say, I'm gay, I'm lesbian, I'm bisexual, I'm transgender, I'm queer, and they're applying to be on the landscape crew. They're applying to sweep floors. They're applying to change light bulbs. They're applying to set up the chairs on campus. And you decline to hire them. And they say from the jump, from the gun going off, using a track and field example, I'm a member of the LGBTQ community. Now, normally they wouldn't be dying to work for a church. Let's accept that as a proposition. But if they did, and you discriminated against them and said, we're not hiring you because we don't hire anybody who's a member of the LGBTQ community, we may have trouble. We're going to have trouble if they bring a claim, because Our Lady of Guadalupe School says you can use the ministerial exception, but the focus of the ministerial exception is the employee's function and a religious organization's definition and explanation of a job's importance. And the landscaping, the sweeping of the floors does not involve religious instruction. It doesn't involve anything having to do with the doctrine of the church. And a deep dive into the case and the previous case, Tabor, which is the name of the previous case from 2012, which in many ways was updated by Our Lady of Guadalupe, we'd have trouble if we had a blanket policy that we don't hire members of the LGBTQ community. And we've got to be careful when it comes to discrimination and the ministerial exception. We cannot make every job position a ministry position, even if it's landscaping, sweeping floors, answering the phones, and changing light bulbs. So that's another update on legal issues having to do with LGBTQ issues in churches. All right. I'm losing my voice. I promised a 59-minute bring your own lunch. We started right at noon. So let's see, I have a question here. All right, is the church required to let a gay couple use the church facilities for a gay wedding legally? That's a great question. You know, I've had this question come up before, even though it doesn't seem to happen very often. Some churches make their facilities available to members of the community. For example, in my law practice, I represent a lot of churches, but I also represent a good number of community associations, condominiums, and homeowners associations. And in my community association practice, I've had a number of board meetings and membership homeowners association meetings in churches where the church figures that it's part of their community outreach to make their facility available to members of the community. And it's occurred to me before that this is a responsible and good notion on behalf of the churches that do it, to have members of the community familiar with their campus and familiar with their church, and to get more people onto the church campus, whether it's a large mainline denomination like an Episcopal church downtown Phoenix, or a large non-denominational church in Peoria, Arizona, for example, which I've done both of those. It makes sense. And I think it's a very good portion of outreach and ministry outreach to have people on the campus to make the church accessible. But the question here becomes, if the church becomes a public place and the church's policy is that the church can be reserved by members of the public for a nominal fee or for a cleaning fee, could someone from the public who's not a member, just any, Joe Public, say, well, I understand that, let's make up a name, St. Scott Carpenter's church in anywhere Arizona has an accessible to the public policy, and I want to use it on this date for my gathering. It happens to be a gay marriage, and I'll pay the cleaning fee. I'll bring my own officiant because I'll have my best friend go online and get ordained by the church of whatever, and do the ceremony. We'll clean up afterwards, just like anybody else who uses the church campus reservation policy for a cleaning fee, just like Del Boca Vista, the condo association across the street, that uses it for its member fee. If the church declines to allow me, in this hypothetical, to reserve the campus because it allows everybody else to use the campus, the HOA, the Boys and Girls Club, the 4-H, whatever, is using the church, and the gay marriage reservation is declined on a doctrinal basis, marriage is between one man and one woman, and the gay marriage reservation files a lawsuit, the question really becomes, what would happen to that lawsuit? My quick thought on it is that the ecclesiastical abstention doctrine would step in, hopefully, and a judge would say, the church can have its available to the public policy, but when the church decided that its doctrine steps in and says, the church can be reserved by members of the public, but doctrinally, we're going to say this use is not okay under our doctrine, I would hope that a judge would agree that the church autonomy doctrine and or the ecclesiastical abstention doctrine would say no to the gay marriage use, if that's the church's decision. All right, other question, and then we'll end 3 or 4 minutes early on our 59-minute bring your own lunch here at the lunch hour. Have I dealt with many churches who host LGBTQ family support groups? This is a great question. From a ministry standpoint, there are a lot of churches that have been working with family support groups that work with families that have had challenges. And, from a ministry standpoint, when I deal with churches and their legal issues, I don't end up working very closely with what churches are doing on the ministry side. But certainly, whatever churches can do with outreach and ministry to the members of the congregation that need help, I certainly encourage that. Always good to have ministry and outreach and support for families that need help. And I always support that, absolutely. Well, thank you all for joining me today. This seminar has been provided, as I said, on April 18th, 2024. We endeavor for this to be accurate as of the day that it's presented. And I'm licensed in multiple states, but this is presented with an Arizona intention. And if you need help, please reach out. Www.carpenter.law. I'm happy to help if I can. Thank you.